Today on Legalese, we will be continuing our discussion on the government's social media mass censorship case of Murthy v. Missouri. Hey, greetings everybody, and welcome back once again to Legalese. As always, I'm your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, just want to remind you guys, if you want to find out more about the show, you can go check out our homepage over at legalespodcast.com. And if you want to get updates and notifications whenever I put out any new content, and I don't just do videos on YouTube, I write articles on Substack, I do an audio-only version of the show, I post to alternative platforms. And whether you want notifications for all of that, or you just want curated notifications for certain content I put out, either way, all you have to do is head over to legaleshow.com, and there you can subscribe to our newsletter and get the notifications you want sent right to you. All right, well, as usual, we have a hell of a lot to get to today, so let's just jump right in. So, as I mentioned off the top, today we are going to be continuing our discussion of Murthy v. Missouri. Now, my first video of this case covered the background and facts of the case, as well as the initial trial, which was then known as Missouri v. Biden. And in that case, the district court would issue a broad preliminary injunction, which I'll just be referring to as the PI, that barred communication from certain actors within the federal government from contacting social media companies on certain issues where they are coercing these companies to censor speech the government doesn't like. Now, additionally, I posted an article to Substack where I put together a syllabus of the case as it came before the Fifth Circuit. And so our main focus today will be the case before the Supreme Court itself. We will be discussing the merits of the case and then doing a deep dive into the oral arguments which were heard earlier this week on Monday. But first, we are going to very briefly talk about this case as it came before the Fifth Circuit. And this happened back in October of 2023. The U.S. Court of Appeals for the Fifth Circuit would rule that the White House and several other federal government agencies had violated the First Amendment by coercing social media firms such as Facebook and Twitter to take down material the government deemed to be misinformation or otherwise harmful. And in Missouri v. Biden, the Fifth Circuit would conclude that the White House, the Surgeon General, and the FBI had coerced social media firms to take down materials that these agencies objected to. And turning to the opinion itself, they said, on multiple occasions, the officials coerced the platforms into direct action via urgent, uncompromising demands to moderate content. Privately, the officials were not shy in their requests. They asked platforms to remove posts ASAP. They asked them to take down accounts immediately and insisted they slow down and demote content. And in doing so, the court notes that the officials were both persistent and angry. And they say that when the platforms did not comply, officials would follow up by asking why posts were still up, saying things like, how does something like this happen? What good is flagging content if it doesn't result in content moderation? I don't know why you guys can't figure this out, and accusing them of hiding the ball, all while demanding assurances that these posts will be taken down. And more importantly, the officials threatened both expressly and implicitly to retaliate against inaction. The court found that officials threw out the prospect of legal reforms and enforcement actions while subtly insinuating that it would be in the platform's best interest to comply. As one official put it, removing bad information is one of the easy, low-bar things you guys can do to make people like me, by which he meant a White House official, think that you're actually taking action. Now, the injunction itself was actually more narrowly drawn than the district court one. And it was done in such a way as to allow both government officials and social media firms to speak freely so long as there is no coercion or significant encouragement, a term which was relatively narrowly defined. So, turning to the wording of the PI, it says that defendants and their employees and agents shall take no action, formal or informal, directly or indirectly, to coerce or significantly encourage social media companies to remove, delete, suppress, or reduce, including through altering their algorithms, posted social media content containing protected free speech. And that includes, but is not limited to, compelling the platform to act, such as by intimating that some form of punishment will follow a failure to comply with any request, or supervising, directing, or otherwise meaningfully controlling the social media company's decision making process. And unlike the much broader injunction that had been ordered by the district court, this one doesn't bar the White House and other agencies from speaking out about social media content moderation policies or contacting firms about them, so long as the contact falls short of significant encouragement. Now, government agencies, essentially, or anyone else, according to this, can indeed condemn social media firms' policies and urge them to change, but they must not be coercive in doing so. And so, moving on to the oral arguments and the merits of the case as it came before the Supreme Court. This is, of course, the really juicy bit here. Now, when this case came before the Supreme Court, uh, it really was a fairly exhilarating debate over the merits of the case during this session of oral arguments. And the arguments made before the court in this case really amounted to a dueling interpretation of the Biden administration's interactions with social media platforms regarding content it viewed as dangerous to public health, democracy, and national security. During the oral arguments in Murthy, the Louisiana Solicitor General said those private contacts combined with public statements condemning the platform's failure to suppress misinformation amounted to government directed censorship, while the U.S. Principal Deputy Solicitor General Brian Fletcher disagreed, saying neither crossed the line between persuasion and coercion. Now, Brian Fletcher began by talking about how the government may not use coercive threats to suppress speech, but it is entitled to speak for itself by informing, persuading, or criticizing private speakers. And he references the landmark case Bantam Books, and he says, like Bantam Books, this case should be about the fundamental distinction between persuasion and coercion. Now, he is here referring to a landmark 1963 Supreme Court case, Bantam Books v. Sullivan. And in that case, the Rhode Island Commission to Encourage Morality, a state created entity, sought to stop the distribution of so called obscene books to kids. So it sent a letter to a book distributor with a list of verboten books and requested that they be taken off the shelves. That request conveniently noted that compliance would, quote, eliminate the necessity of our recommending prosecution to the Attorney General's Department, end quote. And per the Commission's request, police officers would indeed follow up to make sure these books had been removed. And there the court would conclude that this system of informal censorship, which was clearly meant to intimidate the recipients through the legal threat of sanctions and other means of coercion, rendered the distributor's decisions to remove the books a state action. Given Bantam Books' not so subtle asks accompanied by this system of pressure, by which they mean threats and follow ups, was clearly coercive. Now, he claimed that the lower courts entered a universal injunction restricting speech about any content posted on any platform by anyone and binding thousands of officials, including presidential advisors speaking to the public and FBI agents trying to protect the nation from foreign threats. He said that the courts further erred by radically expanding the state action doctrine as well as by mistaking persuasion for coercion.
We'll hear argument first this morning in Case 23-411, Murthy versus Missouri. Mr. Fletcher.
Thank you, Mr. Chief Justice, and may it please the Court. The government may not use coercive threats to suppress speech, but it is entitled to speak for itself by informing, persuading, or criticizing private speakers. Like Bantam Books, this case should be about that fundamental distinction between persuasion and coercion. But unlike Bantam and the case that you'll hear next, this is not a typical suit where a speaker challenges government actions affecting its own speech. Instead, 2 states and 5 individuals are trying to use the Article III courts to audit all of the executive branch's communications with and about social media platforms. That problem has infected every step of this case. Respondents don't have standing at all because they have not shown an imminent threat that the government will cause a platform to moderate their posts in particular. But the lower court still reviewed a vast range of speech by different officials to different platforms about different topics at different times without asking whether it had anything to do with respondents. And the courts then entered a universal injunction restricting speech about any content posted on any platform by anyone and binding thousands of officials, including presidential advisors speaking to the public and FBI agents trying to protect the nation from foreign threats. Even apart from the Article III problem, that injunction rests on 2 fundamental legal errors. First, the Fifth Circuit radically expanded the state action doctrine by holding that even conceitedly non-coercive communications, like the CDC's public health advice, can transform private platforms' editorial choices into state action. And second, the Fifth Circuit mistook persuasion for coercion. It held that the FBI's communications are inherently coercive because the FBI is a law enforcement agency, a theory that even respondents don't defend in this court. And it held that White House officials engaged in coercion because they used strong language or referred in a general way to legal reforms in response to press questions. If this court reaches the merits, it should reaffirm that government speech crosses the line into coercion only if, viewed objectively, it conveys a threat of adverse government action. And because no threats happened here, the court should reverse. I welcome the court's questions.
Now, on the other hand, Missouri Solicitor General will begin by characterizing the government's actions in this case as clearly meeting the threshold for coercion. As the Fifth Circuit put it, the record reveals unrelenting pressure by the government to coerce social media platforms to suppress the speech of millions of Americans. The district court, which analyzed this record for a year, described it as arguably the most massive attack against free speech in American history, including the censorship of renowned scientists opining in their areas of scientific expertise. And he would go on to provide a list of the many actions that can be found in the record where the government clearly went well beyond persuasion, and that the response to these coercive actions by social media companies was frequently to depart from their own policies due to this unrelenting government pressure. And he even points to a specific and I think especially shocking example where a Facebook executive clearly stated that they had went against their own policies because of government pressure. So in an internal email to the former UK Deputy Prime Minister Nick Clegg, Facebook said the reason that it took down certain content was, quote, because we were under pressure by the administration. We should not have done that, end quote. And the Solicitor General for Louisiana will close with one of what I think are the finest and pithiest rejoinders I have ever heard about how a government's right to speak does not extend to persuade platforms to violate Americans' constitutional rights, and that as much as this pressure happened through back channels, these communications only actually became known following the discovery process in this case. This means that the government wasn't using their bully pulpit, they were just being a bully, and that's not bully.
All right, put 'em up. Are you having a bully day? I'm having a bully day. Is everyone having a bully day? Bully! Yes, bully! Oh, thank God we live in this time.
Thank you, counsel. Mr. Agingwaga.
Good morning, Mr. Chief Justice, and may it please the court. Government censorship has no place in our democracy. That is why this 20,000-page record is stunning. As the Fifth Circuit put it, the record reveals unrelenting pressure by the government to coerce social media platforms to suppress the speech of millions of Americans. The district court, which analyzed this record for a year, described it as arguably the most massive attack against free speech in American history, including the censorship of renowned scientists opining in their areas of expertise. And the government's levers of pressure are anathema to the First Amendment. Behind closed doors, the government badgers the platforms 24/7. It abuses them with profanity. It warns that the highest levels of the White House are concerned. It ominously says that the White House is considering its options. And it accuses platforms both of playing total Calvin ball and of hiding the ball, all to get the platforms to censor more speech. Under this onslaught, the platforms routinely cave. Now, last month in the net choice cases, the platforms told you that it's incredibly important that they create their own content moderation policies. But this record shows that they continually depart from those policies because of unrelenting government pressure. Indeed, as Facebook recently disclosed in an internal email to former UK Deputy Prime Minister Nick Clegg, the reason Facebook did that was, quote, because we were under pressure by the administration. We shouldn't have done it. Now, my friend says all this is constitutional because the government has the right to persuade using the bully pulpit. But the government has no right to persuade platforms to violate Americans' constitutional rights. And pressuring platforms in back rooms, shielded from public view, is not using the bully pulpit at all. That's just being a bully. I welcome the court's questions.
All right, let's take some time to talk about initial impressions about the justice's frame of mind in this case. Now, the first thing worth pointing out is that I believe the real rock star of this hearing was Justice Samuel Alito, who was clearly more troubled than the others about the government's actions, and he occasionally even got upset with some of the especially troubling defenses offered by Mr. Fletcher on behalf of the government. And this was good to see. This is a case that should make people upset. Now, while they managed to remain more subdued and even-handed, Clarence Thomas and Neil Gorsuch were clearly equally unimpressed with the government's defense of their actions. On the other hand, Justices Elena Kagan and Sonia Sotomayor, and to a lesser degree, Ketanji Brown Jackson, made it clear that they did not think much of the arguments being made by Louisiana Solicitor General. Although Justice Jackson's concerns, I believe, were actually much more nuanced, and she, I think, actually made a number of very fair points in her criticism of the respondent's case that is not present when Kagan and Sotomayor are going after them. They are taking a much harder and absolute line. Now, somewhere between those two extremes, we had Justice Amy Coney Barrett, who was rather ambivalent. She was certainly unimpressed with Louisiana's defense of their arguments in court, and frankly, with good reason. And actually, in my personal opinion, I think both lawyers, both those for the federal government and Louisiana, would end up doing pretty terrible jobs during the seriatim portion of the arguments. The opening arguments were both very good, but during the question period, they both did a fairly poor job, but for very different reasons. So in the case of the Deputy Solicitor General, Brian Fletcher, he just kept contradicting himself. On the other hand, the Louisiana Solicitor General was often just incredibly vague and unclear when answering questions to help discern how exactly he says we can define the difference between persuasion and coercion. Now, while I do think, giving a very careful listen, that his arguments were consistent, he did a very poor job of explaining them, and several of the justices felt like he was giving shifting and inconsistent answers to their questions. Now, his argument did come together more towards the end, as I think he realized just how unfocused he was sounding, but by that point, I think the damage was mostly done. And as for Justices Brett Kavanaugh and the Chief, they both said very little. And from what little they did say, I am worried that they are both leaning towards siding with the government in this case. And in fact, given the arguments, what I see is I think that there are three justices, in Justices Thomas, Gorsuch, and Alito, who are prepared to uphold the preliminary injunction. There are 3 justices in Kavanaugh, Barrett, and the Chief who appeared to be looking to uphold government speech rights. And then there are 3 justices in Kagan, Sotomayor, and Jackson who are for upholding the government's role in working actively with these platforms. So let's move on to the petitioner's seriatim portion and the questions that they faced from the court. So following Brian Fletcher's opening arguments, the questions began with Clarence Thomas, who was interested in establishing whether the only proper standard upon which to decide whether we are dealing with persuasion or coercion is the Bantam Books case. He would also ask about the reach of the state action doctrine and whether it can be applied to government or private parties. And rather interestingly, he asked about the constitutional basis for the right to government speech, upon which much of the government's arguments lie.
Court's questions.
Mr. Fletcher, is the coercion encouragement framework out of Bantam Book the only way to look at this case?
So I think there are 2 ways to look at this case. I think one of them is the coercion inquiry, which we think comes from Bantam Books. You can think of that as an aspect of state action because when private parties are compelled to act, as the court said in Halleck, they become state actors. We think that's the right way to think about this case. Respondents in the lower courts have also proposed a different way, the state action way. They've suggested that even absent coercion, the government speech, if it encourages, in some colloquial sense, private action, it can turn that private action into state action.
Do we just so I understand your argument, do we normally apply state action doctrine in cases involving the government or private parties?
Both, I think. In some state action cases, you're asking someone who's suing a private party and alleging that that private party is bound by the contours of the First Amendment or other constitutional provisions because they're state actors. You see some suits like that look like this, suits against the platforms, suits against Stanford University, which is referenced in its amicus brief here. But you also see suits against the government based on conduct by private parties. That was the case in Blum, and that's the theory that respondents are pursuing.
Are there any, one final question. You continue to refer back to government speech.
Injunction affects the government's ability
just
to engage
for my
in its own
edification,
speech.
what's the constitutional basis or for government
Now, she would
speech?
claim not to know.
So the court has said, I think, that the government is
meant when
entitled
they
to
use
speak
the
for
term
itself. It's not a right that
significantly
comes from the
encourage,
First Amendment. It's a
which
feature
is
of our
odd
constitutional
because the Fifth Circuit
democracy.
actually
As the
gave
court
a
has
very
said, the government
specific
couldn't function
definition,
if it couldn't
and it
express
is
points
as
of view.
follows.
In Walker, the court explained, for example, that the government has to be able to
For
run a
encouragement,
vaccination campaign at
we read the
times
law
of
to
public health
require that a
crisis. That's a
governmental
major
actor
part of what was
exercise
going on
active,
here.
meaningful
So the court
control
hasn't
over
located
a
it in
private
any
party's
specific
decision in
constitutional
order
provision.
to
It's just part of
constitute
democratic
a state
governance.
action that reveals itself in 1. Entanglement in a party's independent decision-making, or 2. Direct involvement in carrying out the decision itself. Now, I think perhaps what Justice Sotomayor actually meant was she doesn't understand the meaning of that term in the relevance of this case. Because this is a case that both sides are arguing is consistent with Bantam Books, and the standard in Bantam was coerce. And so to use a term not consistent with Bantam defies meaningful definition. At least that's what I think Justice Sotomayor is getting at. Now, significant encouragement is a legal term, and it was a term that was coined and defined by the Supreme Court in the Blum v. Uretsky case. And frankly, trying to stick that term in as part of an argument that doesn't ever speak to Blum and tries to instead lump his precedent in with Bantam Books does, I think, muddy the waters in an unhelpful way. Therefore, really, the most effective way this case can restrict First Amendment violations inherent in the facts of the case would be not to operate on this coercion or significant encouragement rule, but to instead try and operate on a bright line rule that would clearly establish the definition of the term coercion to social media as a matter of constitutional construction. And this would mean dropping the significant encouragement standard entirely. Now, what Sotomayor had been looking for here was a clear answer about how an injunction against the government to coerce social media companies to remove, delete, suppress, or reduce posted social media content containing protected speech had caused harm to the government. Rather than giving Justice Sotomayor the specific example she was asking for, he instead just gave a rambling answer that had little connection to the question at all.
Democratic governance.
Explain to me what exactly is the injunction doing? Meaning, how is it affecting your speech, the government's speech? I know there's a lot of defendants, and it says to encourage or significantly to coerce. That's a legal term.
Yep.
Or significantly encourage, and you're questioning what the meaning of significant encouragement is. And I'm not sure I know exactly what the Fifth Circuit meant, but we can figure that out. Let's just use to coerce social media companies to remove, delete, suppress, or reduce, including through altering their algorithms, posted social media content containing protected speech. How is that harming the government? I want some specifics.
Exactly, right. So I think the problem with that, we don't say that the government can coerce private speakers. That is prohibited by the First Amendment. But the problem with the Fifth Circuit's injunction saying don't coerce or significantly encourage is that it comes at the end of 80 pages of legal analysis holding that the government had done those things by, for example, when the FBI would send communications to the platforms saying, for your information, it has come to our attention that the following URLs or email addresses or other selectors are being used by malign foreign actors like Russian intelligence operatives to spread disinformation on your platforms. Do with it what you will. That, the Fifth Circuit held, is coercive because the FBI is a powerful law enforcement agency. And I think if the injunction were put in place, the FBI would have to think very hard about whether it could continue to do that.
So, apparently, at least going off that exchange, what he thinks is that government agents having to decide whether a certain action constitutes a violation of our constitutionally protected individual rights before they take action would constitute an active, tangible harm to the FBI somehow. Now, at the end of that exchange with Sotomayor, this was the point where Justice Alito would jump in, and he just goes to town. I mean, he raises the black flag, clearly signaling that no quarter will be asked and none given, and just dives right in to the major discrepancy between what Mr. Fletcher is claiming the facts of the case show and what the actual facts of the case actually show. He points out that if even one of the plaintiffs in this case has standing, which is something that the government is arguing against, but he says if even one has standing, the courts are required to get to the merits. He then points out that even the government seemed to agree in the exchange with Justice Sotomayor that there was one plaintiff in the case, Miss Hines, whose Facebook page was restricted when the complaint was filed. He asked why that shouldn't be sufficient to show injury or imminent threat of future injury. Now, Fletcher again concedes that she had suffered an injury, but his argument was one of traceability. Namely, he is saying they have not drawn a connection between that injury and government action. Now, Justice Alito would counter that fact by pointing out that the district court found that the injury was traceable to government action, and that after reviewing that finding for themselves, the Fifth Circuit accepted that traceability argument as well. He points out that it is standard practice for the court to be highly deferential to findings of fact in cases that come to them on review, and that the only time the court will reverse findings of facts by two lower courts is essentially, he says that it would be incumbent upon Mr. Fletcher to show conclusively that the finding was erroneous, and that the government hasn't even attempted to show such a finding. They have just claimed that without evidence. Now, Fletcher's response to that is to complain that the courts had established traceability too loosely, and that they didn't identify a single government action and trace it to a single consequence, and therefore, you could not establish traceability. However, Alito asks him if it is necessary as a requirement to pinpoint a single action and a single consequence to establish traceability, to which Mr. Fletcher quite properly says no. Now, Alito moves on to making the point that traceability is ultimately a question of causation, to which Fletcher completely agrees, at which point Alito turns to the precedent set in the Mount Healthy case, which suggests that to prove causation, they are merely required to show the government's action was a motivating factor in the intermediary's decision, which is a factual finding that, again, Fletcher doesn't dispute. But he says he doesn't think any of the government's actions had any effect whatsoever on the policy decisions cited in this case.
Satisfy Article 3.
Mr. Fletcher, let me follow up on that. If even one of the plaintiffs has standing, then we're required to get to the merits. So let me ask you about Ms. Hines. And as you just mentioned, she must have faced an imminent threat of future injury at the time when the complaint was filed, and that injury must be traceable to the actions of the government. So in the first part of that, imminent threat of future injury, her Facebook personal account was restricted at the time when the complaint was filed. So why isn't that sufficient to show a threat of an imminent threat of future injury?
We're not disputing that when the private platforms moderated the plaintiff's pages or their posts, that's an injury in some sense. We haven't disputed that. They suffered that injury. We've disputed the traceability question and then the redressability question.
Right. So on traceability is basically a question of causation, right?
Agreed.
All right. Both the district court found that the injury was traceable to the government's actions, and the Fifth Circuit accepted that finding, reviewed it, and accepted it. So that's two lower courts. We don't usually reverse findings of fact that have been endorsed by two lower courts, and you haven't attempted to show that it was clear that that finding is clearly erroneous.
So respectfully, Justice Alito, I disagree with that. I think that the Fifth Circuit and the district court applied too loose a notion of traceability. They didn't try to say this post or any action against Ms. Hines was traceable to any action by the government. They did what the red brief calls a bird's eye view of traceability. They said the government is talking to the platforms a lot. The platforms are doing moderation, and so we'll just assume that all of that moderation is traceable to the government.
Well, do you think that it's necessary to identify a single government action and then trace it to a single consequence? Do you think that's required?
No, but I think you have to trace some government action to some consequence that befell you. And maybe I could just be specific about this, because we challenged this in our opening brief, and the red brief comes back at pages 19 to 21 and offers up what I take to be their best examples of traceable harm. And I invite you to go look at the pages of the record that they're citing, because often what you find is that they're citing moderation of their content that happened either before the challenged government actions to which they're referring or long after.
All right. I have looked at that. On the issue of causation, under Mount Healthy, are they required to show anything more than the government's action was a motivating factor?
I don't know the answer to that in all cases, and I'm reluctant to make sort of broad statements about what the traceability requirement demands in different circumstances. I will say here, we're not disputing that. We're saying that they haven't shown any causal connection between the —
Has no effect whatsoever.
Right. And
both the lower courts were wrong on that.
I think they were, because, again, they did this blunderbuss approach where they said the government is talking to the platforms about moderation and the platforms are moderating content. But the platforms were moderating this content long before the government was talking to them. They had powerful business incentives to do the same thing. The acts of moderation were consistent with the platform's own policies. And this is, I think, another telling fact. In those red brief examples that we talked about on pages 19 to 21, some of them involve platforms like LinkedIn that wasn't even the subject of the challenged White House and Surgeon General's office communications with the platforms.
And at this point, Justice Kagan would jump in and ask if there were any factual findings with respect to standing that the court is required to give a clear error review to. Now, Fletcher would say that they absolutely have to do that with findings of historical fact. Now, I don't have time for a comprehensive discussion about the meanings of legal and historical facts, so for now, I will adopt Fletcher's view of what historical fact-finding would mean in this case. So for him, the idea is that pieces of content were moderated, that the government made certain statements, and if there had been findings that said Facebook deleted the post because of these communications by the government, that would be a factual finding of historical fact, but he claims there just aren't such findings.
office communications with the platforms.
Do you think that there are any factual findings with respect to standing that we are required to give clear error review to?
I think findings of historical fact, absolutely. We're not fighting that. So the idea that pieces of content were moderated, that the government made certain statements, and if there had been findings that said Facebook deleted this post because of these communications by the government, that would be a factual finding of historical fact, but there just aren't such findings.
Right. I mean,
Now, in response to this, Justice Gorsuch comes in and gets Fletcher to immediately and completely contradict himself.
Legal standards.
So, Mr. Fletcher, I just want to nail down what your views are on the legal standards. Sure. On traceability, you're not disputing that a motivating factor is enough.
We haven't made that argument here. That's right.
Okay. And then on redressability, what's your view of the legal standard the court should be applying?
I think, again, it has to be some showing that I think likely to redress the injury is the standard from Lujan. So it doesn't have to be certain, but you have to make some showing that an injunction against the government will stop the platforms from doing what they want.
In Massachusetts versus EPA, we've said likely to some extent. Does that strike you as correct?
I think in the context of Mass versus EPA, maybe where you're talking about a problem of degrees, here where the concern is, are the platforms going to moderate my posts or not, and are they going to do it because of the government or not, and will an injunction against the government stop Facebook and
to some degree? Is that an acceptable standard to the government?
I guess
I just want to know what my yardstick that I'm supposed to measure these allegations against, and there's not a lot in your brief about it. So I take likely from Lujan.
Yeah.
I take to some extent from Massachusetts versus EPA, and I take the statement in Larson that it doesn't have to redress every injury.
Agreed.
You agreed with all of that?
Except that to some extent I think was there the state's injury was about rising sea levels, and so to some extent means it doesn't have to solve the problem, it has to help it a little bit. This is more discrete acts of content moderation.
Do you agree with that standard, though, that to some extent, if they could show that their injury would be remedied to some extent by an injunction, that would be enough?
Correct. So if they're likely to face moderation on 10 posts and an injunction against the government would make it 8, that's enough.
Yeah. Okay. And then just flipping back to traceability, I'm sorry, I forgot to ask. The substantial motivating factor obviously means it doesn't have to be proximate cause.
Agreed.
Okay. Thank you.
And at this point, Justice Alito would agree with and then elaborate on precisely what Justice Gorsuch had just said.
Thank you.
Mr. Fletcher, when I read all of the emails exchanged between the White House and other federal officials and Facebook in particular, but also some of the other platforms, and I see that the White House and federal officials are repeatedly saying that Facebook and the federal government should be partners. We're on the same team. Officials are demanding answers. I want an answer. I want it right away. When they're unhappy, they curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms, and they want to have regular meetings. And they suggest, they suggest rules that should be applied, and why don't you tell us everything that you're going to do so we can help you and we can look it over. And I thought, wow, I cannot imagine federal officials taking that approach to the print media, our representatives over there. If you did that to them, what do you think the reaction would be? And so I thought, the only reason why this is taking place is because the federal government has got Section 230 and antitrust in its pocket, and it's to mix my metaphors, and it's got these big clubs available to it, and so it's treating Facebook and these other platforms like they're subordinates. Would you do that to the New York Times or the Wall Street Journal or the Associated Press or any other big newspaper or wire service?
So there's a lot packed in there. I want to give you one very specific answer first and then step back out to the broader context. So specifically, you mentioned demanding an answer right away and cursing them out. The only time that happens is in an email that's about the president's own Instagram account. It's not about moderating other people's content.
Okay, well, put that aside. There's all the rest. So constant meetings, constant emails. We want answers. Right. We're partners. We're on the same team. Do you think that the print media regards themselves as being on the same team as the federal government, partners with the federal government?
So potentially in the context of an effort to get Americans vaccinated during a once-in-a-lifetime pandemic. And I really think that piece of context, it doesn't change the First Amendment principles, but it's relevant to how they apply here. And I think it's important to understand that at this time, this was a time when thousands of Americans were still dying every week, and there was a hope that getting everyone vaccinated could stop the pandemic. And there was a concern that Americans were getting their news about the vaccine from these platforms, and the platforms were promoting, not just posting, but promoting bad information.
I understand all that, and I know the objectives were good. But once again, they were also getting their news from the print media and the broadcast media and cable media, and I just can't imagine the federal government doing that to them. But maybe I'm naive. Maybe that goes on behind the scenes. I don't. But it struck me as, wow, this is not what I understand the relationship to be. That's all.
But I do. I think this is important because I have the same reaction that you do, that these emails look unusual. I think the idea that there'd be back and forth between the government and the media isn't unusual at all. When the White House press secretary on July 16th is asked about this by the press at the time, what she says is, of course we talk to the platforms just the way we talk to all of you when we have concerns about what you're doing, when we have information that you might find helpful. Now, there's an intensity of the back and forth here, and there's an anger that I think is unusual, but the context for that, I think, is that these platforms were saying publicly, we want to help. We think we have a responsibility to give people accurate information and not bad information. And we're doing everything we can to meet that goal. That's where this language of partnership comes from. It's not just from the White House. It's these platforms, which are powerful, sophisticated entities, saying we're doing the best we can. And the anger, I think really most of the anger when you read the emails, and I appreciate that you have because I think you have to look at them in context, the anger is when the officials think that the platforms are not being transparent about the scope of the problem or aren't giving information that's available.
Well, let me ask you one more question, and then I'll stop, at least for now. You make a big point in both your brief and your reply that states don't have First Amendment rights. But are you saying that they may have a free speech right, but it comes from someplace else, or they don't have free speech rights? Do you think that the federal government could prohibit a governor or the top-ranking public health official in a state from speaking to the residents?
No, I don't think it could, and I want to be clear. We're not denying that they have speech rights. We're saying that those things, like the federal government's speech rights, come from the structure of our Constitution, not from the First Amendment. This is a First Amendment case, and I think really what's happening here is that these states, which were the motivating factor behind the suit, the only plaintiffs in the initial complaint, are really trying to represent and to litigate the First Amendment rights of their citizens on their citizens' behalf. We think that's an end run around the limit on parents patriae standing, just like the one the court rejected.
Do you think
And at this point, Justice Kavanaugh and Brian Fletcher would both try to defend the government's berating of social media companies as something commonplace within the relationship between the government and the media. And at that, Alito would jump in with a rather devastating rejoinder.
Staff and members of the press.
Well, I don't know whether our public information officer is here today, but maybe she should take a note about this. So whenever they write something that we don't like, she can call them up and curse them out and say, why don't we be partners? We're on the same team. Why don't you show us what you're going to write beforehand? We'll edit it for you, make sure it's accurate.
So, Justice Alito.
Now, while Justice Kavanaugh thinks that this aggressive berating is a common occurrence in Washington, he would say, as he points to the language that was used about partnering with government, that comes up quite a bit between the government and these companies, that does strike him as a rather unusual thing for the government to do, and he asks for Fletcher's thoughts, to which Fletcher seems to suggest that the First Amendment isn't so much a set of principles as much as a conditional and contextual standard.
To challenge these sorts of regular back and forths.
on the partners point, though, that does strike me as unusual. I mean, what do you think about that?
So that, I think, is traceable to the unusual feature here of this is not the government where the platforms were saying, we don't want to deal with you about this. And the government is calling them up and saying, no, we're partners. Let's be partners. You could imagine a situation like that where there might be a problem. You might start to think that that starts to shade into coercion. But here it's an open door. The platforms are saying publicly, because they're getting public criticism about this from other people too, from the press, from the World Health Organization, from others. They're saying publicly, we want to do our part. We recognize we have a responsibility, that we're a source of information for people, and we want to be a source of good information. And so when the White House calls and says we have some concerns about this, they say, we agree. You know, that's a good point you make over here. We disagree with you over here. We're not going to go this far, but we agree with you.
Now here, Justice Jackson jumps in for the first time with a very interesting point, in that it seems to her the government is accepting, if not promoting, the view that the coercion persuasion argument is a binary, and that the former is always prohibited and the latter is always acceptable. However, she points out that this does seem inconsistent with the court's First Amendment jurisprudence, and she doesn't understand why he wouldn't be discussing this as a matter of heightened scrutiny, in which the question is not, was this coercion, and if so, we simply put a blanket ban on that activity. Instead, First Amendment jurisprudence would say that the government can coerce speech in certain circumstances under the strict scrutiny standard, where the actions further a compelling government interest and the scope is narrowly tailored.
I agree with you.
And Mr. Fletcher, whether or not that ultimately becomes a First Amendment violation, I mean, I appreciate the coercion point, and that's sort of the government's first point with respect to the merits of this. But I'm interested in your view that the context doesn't, quote, change the First Amendment principles. I mean, I understood our First Amendment jurisprudence to require heightened scrutiny of government restrictions of speech, but not necessarily a total prohibition when you're talking about a compelling interest of the government to ensure, for example, that the public has accurate information in the context of a once-in-a-lifetime pandemic. So I'm just interested in the government sort of conceding that if there was coercion, then we automatically have a First Amendment violation.
So I'm not conceding that that would be the case. I could imagine that in times of pandemic, if there were actual restrictions, maybe those would be justified. But our position here, because we think it's the position consistent with the facts, is that there wasn't any coercion to begin with.
Mr. Fletcher.
Now, from here, Neil Gorsuch would once again get Fletcher to completely contradict himself on what qualifies as coercion by asking about whether coercion only occurs in the form of a threat, or can it also come from an inducement. Fletcher agrees and says that in some senses, really, an inducement is the flip side of a threat. But he points out that, unlike the other jawboning case that the court was set to hear that very day, in fact, which was NRA v. Vullo, which is a case in which the government does seem to pair threats and inducements by offering companies either the threat of prosecution or an offer of leniency to get banks and insurance companies to stop doing business with the NRA. And from here, Justice Gorsuch would then get into various statements that have been made, statements which we did cover extensively in my last Murthy video, in which the government called on social media companies to engage in more censorship, in which they would say that a failure to more aggressively censor might very well warrant bringing an antitrust suit against a company, or that it may necessitate a repeal of Section 230. While Fletcher agrees that those statements are indeed coercive in theory, he tries to argue that they are somehow not coercive in fact, which I found to be just bizarre. Especially because I really don't think he realized just how completely he was contradicting himself from one sentence to the next.
Any coercion to begin with.
Mr. Fletcher, on that point, you mentioned coercion repeatedly in terms of threats. Can there also be coercion, in your view, in terms of inducements?
We think there can. I think often a threat or an inducement is sort of the flip side, one or the other. I think in the next case you could construe it either way, threat of prosecution, offer of leniency. So we acknowledge that it can be both, but it has to be a threat or an inducement of some concrete government action, not just of more government speech.
And hypothetically, and I'm not saying this happened here, but would a threat or an inducement with respect to antitrust actions qualify as coercion?
Sure.
And a threat or an inducement with respect to Section 230 qualify?
So I think that one's harder for two reasons. One is that these are executive branch officials who don't have the ability to unilaterally enact 230 reform. And I think the question
is... But they have a power to influence that.
But the question is...
Would that be enough to say we're going to, if you don't do X, we are going to change our position on Section 230?
So potentially yes as to legislation. 230, if I could just get this out, though, I think is different because 230 is about content moderation. It's about this very issue. And I think a government official has to be able to say, I support Section 230 reform because I'm concerned about these things. And also, in the meantime, I think platforms should be doing better.
I understand that. But in terms of advocating for change of Section 230, that could be coercion in your view.
If it were framed as a threat. Our position is that wasn't done here.
And how about saying you're killing people? Could that be coercion in some circumstances? That if you don't change your moderation policies, you're responsible for killing people?
So I think that one is much harder. That's a statement that President Biden made off the cuff to
I'm
the
not,
press.
I'm not, listen, I'm not talking about the context specific issues, and I understand you have arguments there, but could that in some circumstances, an accusation by a government official that unless you change your policies, you're responsible for killing people, could that be coercion?
So I find it hard to imagine a situation where that sort of public statement could be. I'll acknowledge, as you say, context matters a ton, and so I don't want to say it's impossible. All I'm saying is it didn't happen here. The president said this to the public in the middle of the pandemic, and then 3 days later, I think this is important, he clarified. He said, I'm not saying Facebook is killing people. I'm saying the people spreading misinformation are. And when he was asked, will you hold the platforms accountable? He was explicitly asked this, will you hold them accountable if they don't do better? He said, I'm not looking to hold anyone accountable. I just want everyone to look in their mirror and imagine what would happen if this misinformation was going to their loved ones. I think it's clear that this was exhortation, not threat.
Thank you, Mr. Fletcher.
Now, Chief Justice Roberts would jump in, and he was primarily concerned with understanding of what is the threshold at which persuasion becomes coercion.
I think it's clear that this was exhortation, not threat.
Thank you, Mr. Fletcher. How are we supposed to evaluate that question and what the level at which coercion kicks in? I mean, if you're trying to coerce or get a particular result out of a media outlet, is it enough to say, if you don't do this, we're going to move your reporter's cubicle down the hall? Or how do you evaluate when it constitutes coercion in this context?
So let me start with, I think Bantam Books has been the lodestar for the lower courts that have mostly coalesced with some errors in application like this case around the idea of the question is it a threat or a statement that a reasonable person would understand viewed objectively and in context as an implicit or explicit threat of some adverse government action threat. But in general, I think our position is if there's something that the government is saying that we're going to exercise government power in some way unless you change your speech in some way or stop distributing the speech of others, if it's reasonably understood as that sort of a threat, that's a First Amendment problem.
Well, but
so I think that points out the context sensitivity, and I think, as is usually the case when the court says it's a reasonable person test, it's a reasonable person with knowledge of all the facts, and I think that would include the prior course of dealing between the relevant government official and the relevant recipient. I think here that really strongly reinforces the idea that there wasn't coercion. These were sophisticated parties. They routinely said no to the government. They were open about it. They didn't hesitate to do it. And when they said no to the government never engaged in any sort of retaliation. Instead, it engaged in more speech. Ultimately, the president and the press secretary and the surgeon general took to the bully pulpit. We just don't think that's coercive.
And Justice Thomas would jump on top of this as well, trying to present different opinions under which coercion could be achieved through other means, such as by the government partnering up with social media companies.
Mr. Fletcher, back to my point about coercion. Couldn't you simply censor someone or prevent other speech by others by agreeing with the platforms as opposed to coercing the platforms?
I guess I'm not sure what you mean by agreeing with the platforms.
Well, you just worked together, said, look, we're right, they're wrong. Let's work together. We're on the same team. Let's work together to make sure that this misinformation doesn't gain sort of any following.
So I think as long as the platforms are exercising their own independent judgment, that's what the First Amendment protects. It says we don't want the government messing
So
with
you're saying that the government can't censor by coordinating with private parties to exclude other speech?
I'm saying that when the government persuades a private party not to distribute or promote someone else's speech, that's not censorship. That's persuading a private party to do something that they're lawfully entitled to do. And there are lots of contexts where government officials can persuade private parties to do things that the officials couldn't do directly.
So you really don't see any difference between the government coordinating with the platforms to exclude other speech and persuading the platforms to do this, to not engage or permit other speech?
I guess I'm not seeing it, and I think that what happened here was definitely on the – if you do think there's a difference between those two things, I guess my argument here would be that what happened is on the persuasion side of the line, because you do see that back and forth of the platforms throughout the process saying no repeatedly when they disagree with what the government is asking them to do. And I think that that tells you that what was happening here is what the First Amendment protects, which is private speakers making independent judgment, informed by, maybe even influenced by the government.
So there's no difference between the platforms meeting and working out an arrangement not to permit certain speech and the platforms working with the government to do the exact same thing. There's no difference.
Well, I think if the platforms entered into some agreement amongst themselves, that might raise issues under different provisions of the law. The modest point I'm making is just that the government doesn't violate the First Amendment when it persuades a speaker to not distribute speech by someone else. That's
At this point, Brett Kavanaugh would chime in and ask Fletcher to elaborate on his key argument that to qualify as coercion, the standard the government would suggest is the threat of adverse government actions. Fletcher agrees with this and once again stresses that he believes there was no threat of adverse government action at any point in any of the exchanges at issue. To which Kavanaugh would ask, what if the government said, "We don't want you to publish this story, and if you do, we will pursue antitrust actions against you"? Would that be problematic under your standard of threats of adverse government action? To which Fletcher quite unbelievably replies, that would be a huge problem, yeah.
Justice Kavanaugh?
Just so I understand, your key legal argument is, I think, but correct me if I'm wrong, that coercion does not encompass significant encouragement or entanglement, and that it would be a mistake to so conclude because traditional everyday communications would suddenly be deemed problematic.
Exactly right. And really that what the lower courts have done here, I think, is to go beyond the coercion test and sort of to openly say, we're going to open up this state action encouragement door. And that, I think, risks turning the platforms and lots of other entities that are interacting with the government into state actors and restricting their editorial choices under the First Amendment.
By coercion, you mean threat of legal consequences, or do you
adverse government action?
Adverse government action. Okay. Then on the killing people hypothetical or not hypothetical, the statement. I mean, that raises kind of national security analogies. I don't know what your experience is if you've looked into this, but it's probably not uncommon for government officials to protest an upcoming story on surveillance or detention policy and say, you know, if you run that, it's going to harm the war effort and put Americans at, risk.
I can't profess to have had personal experience with that. I know it has happened. The Night Brief talks about some examples. And I think that's an example of a valuable sort of interchange as long as it stays on the persuasion side of the line. I think newspapers want to know if they're publishing a story might put lives at risk. And they don't have to listen to the government, but that's information that they can consider in exercising their editorial judgment.
If they tack on to that, and if you publish the story, we're going to pursue antitrust action against you.
Huge problem, yeah.
Right. Okay.
So if you haven't seen my past video on Murthy, which you really, really should actually, before you watch this, I would say, but I guess it's too late now, but you should go back and watch it, because if you had, you would know why this was so dumb. Because on May 5th of 2021, then White House Press Secretary Jen Psaki publicly began pushing Facebook and other social media platforms to censor COVID-19 misinformation. At a White House press conference, Psaki publicly reminded Facebook and other social media platforms of the threat of legal consequences if they do not censor misinformation more aggressively. And Psaki would directly linked the threat of a robust antitrust program with this censorship demand.
The president's view is that the major platforms have a responsibility related to the health and safety of all Americans to stop amplifying untrustworthy content, disinformation and misinformation, especially related to COVID-19, vaccinations, and elections. And we've seen that over the past several months, broadly speaking. I'm not placing any blame on any individual or group. We've seen it from a number of sources. He also supports better privacy protections and a robust antitrust program. So his view is that there's more that needs to be done to ensure that this type of misinformation, disinformation, damaging, sometimes life-threatening information is not going out to the American public.
Now, that clip was, for me, truly one of the most disturbing of all the threats that came out of this. Now, it beggars belief that the White House press secretary could say that if a social media company doesn't comply with unconstitutional demands by the government to censor viewpoint-based speech, that they would take legal action by not just using, but blatantly abusing antitrust laws and bring an antitrust suit. Because the point of an antitrust suit is to regulate a company for engaging in anti-competitive conduct. Here, she is clearly saying that they will use this as a punitive measure to punish a company for not censoring a citizen based on viewpoint discrimination. So it verily boggles the mind to hear another representative of the Biden White House say, would threatening antitrust actions against a company if they didn't follow some communication from the government to censor speech more aggressively be problematic? Yes, that would be very problematic. Now, this, of course, was nowhere near the only time that the Deputy Solicitor General referred to things the Biden administration unquestionably did as clearly being coercive and violative of the First Amendment. Now, the last noteworthy exchange that came with the petitioner's Syrian portion was a final series of questions by Justice Barrett. So she also addressed the rationale of government and social media coming together as partners to fight misinformation, and she says, even though that's entirely voluntary, wouldn't that be state action? And here, again, Fletcher says, actually, yeah. Depending on the context, that does start to veer into state action, which would make any decision carried out under that partnership decision a clearly traceable action to the government, which once again is a stunningly stupid remark by the government.
Coercion. So what if Facebook said, and this is counterfactual, it's not what happened in this case, but what if Facebook said, you know what, we're partners, we're on the same team, this is a once-in-a-lifetime pandemic, and we think it would be most efficient and most helpful for the public good for us to just turn over our content moderation to you. That's not coercion, that's voluntary on Facebook's part, but wouldn't it be state action then?
So to me, it starts to veer over, and obviously with all the caveats, state action is incredibly context specific. I don't want to be definitive, but to me that starts to verge more over into the joint action. We're doing something together. The government is doing things. It's actually making decisions. It's not just advising or persuading the platforms. I think the rubric that may well be state action, but the rubric would be, I think, more sound in the joint action cases than under significant encouragement, which has never been just us trying to persuade you to do something.
How do we
context? I think you could reserve and say it'd be a very different question if you're talking about the government and the platforms acting together, turning over operational control, integrating their operations. That's a different case. It might present hard state action issues, but it's just really not the kind of issue here.
And no.
All right, and with that, we are moving on to the respondents' questions from the court. And this was the question and answer between the Louisiana Solicitor General and the justices. Now, Clarence Thomas would start off by questioning and asking really sort of a similar question to the one that he had posed to Fletcher about whether you need to meet a burden of proving coercion for them to win the case, or could coordination accomplish the same thing?
The court's questions.
Counsel, I know your argument is basically a Bantam book argument, But do you need coercion in order to, do you think that's the only way you could make your case? Or could you coordination accomplish the same thing? That is, the government is censoring by joint actions with the platforms as opposed to coercing the platforms.
Your Honor, we don't need coercion as a theory. That's why we led with encouragement in our red brief. And I would point the court to what it said in Norwood, which is the court or the government cannot induce, encourage, and promote private actors to do directly what the government can't itself do directly. And that's, I think, the principle that's guiding here, which is regardless of the means that the government tries to use to pressure the platforms to commit censorship against third parties, the Constitution really doesn't care about that. It's the fact that what the government is trying to accomplish is the suppression of speech. And I would say, Your Honor, I mean, that's exactly how you address this question in Bantam Books. You asked, did the government set out to deliberately suppress speech? The answer in that case was absolutely yes, and that's absolutely the answer in this case here. And I guess, I would say, when this court considered Bantam Books, one of the key things about the analysis in Bantam Books was that it was an obscenity case. And, the court struggled with whether the states had the right to police the line between legitimate speech and illegitimate speech. And that was why you were talking about coercion in that case. You were asking whether the state
I'm
went
sorry.
too far.
At this point, we would see Justice Jackson jump in with, I think, an important and overlooked argument, largely overlooked by both sides, which is how the arguments from both sides really do seem to fly in the face to First Amendment jurisprudence, and that the issue isn't merely was there coercion, and that if so, is categorically unacceptable, but is there coercion, and if so, can this coercion meet the rigor of strict scrutiny? And Louisiana would spend the vast majority of the time completely misunderstanding Justice Jackson's questions and gives the kind of answers that you would frankly expect from someone who doesn't understand the question they are answering.
Legal doctrines.
No, Your Honor, the fundamental principle, and this comes from Norwood and it's central to this Court's First Amendment cases, its Fourth Amendment cases, that the government can't do indirectly what it's prohibited from doing directly. And that's what you see happening in Bantam Books. That's what you see happening in a case like this. Because time and again, there were times where the social media platforms had policies that didn't go far enough in censoring the speech that the government wanted them to censor.
But whether or not the government can do this is something I took up with Mr. Fletcher. Depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the Internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate
All right.
narrow
So
tailoring.
not every situation in which the government engages in conduct that ultimately has some effect on on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again, because if you control
But that's not the test for First Amendment violations.
Your Honor, this flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
It can, Your Honor, and I guess what I would say is that the courts below never got to strict scrutiny because the government never raised it. This has never been litigated. The question in this case is whether at the front end the government itself has undertaken
Is the coercion, is the state action, right? That's the question in this case.
And I would urge the court to address the state action issue just like you addressed it in Bantam Books.
Now, at this point, Justice Kagan would jump in, and she wants to return to a point that Justice Kavanaugh had made during Fletcher's seriatim portion of the hearing, where she talked about her own experience in the White House press secretary's office.
In general, you're speaking on behalf of the United States. Again, my experience is the United States, in all its manifestations, has regular communications with the media to talk about things they don't like or don't want to see, or complaining about factual inaccuracies. But be interested in what you want to describe about that.
Now, of course, what she is talking about is the fact that both Justice Kavanaugh and herself, Justice Kagan, have served in the White House press secretary office. Now, Kavanaugh would serve under Bush II, and Kagan would serve under Obama, which would obviously be two very different administrations. I mean, not in terms of policy. They were both imperialist warmongers who did their best to spend our nation into bankruptcy, and they both seem very fond of locking people up for using drugs that they themselves had a history of abusing themselves, but, I mean, stylistically, they were a different administration. For example, George Bush was the kind of guy who was very ashamed of the fact that he used to do a ton of cocaine, whereas Obama was a guy who used to brag about how he used to do a ton of cocaine. The point being, though, that apparently both Democratic presidents and Republican presidents think that they have the right to yell at journalists who print stories they don't like, and it seems that somehow Justices Kavanaugh and Kagan expected those points to reflect well on the Biden administration, rather than just reflecting poorly on the Bush and Obama administration.
And could I just understand, because it seems like an extremely expansive argument, I must say, encouraging people basically to suppress their own speech. So, like Justice Kavanaugh, I've had some experience encouraging press to suppress their own speech.
Yeah, and I would say in the Meinring case that you're describing to me, it's the government going after the speaker itself and trying to get them to change their speech. What's so pernicious here is that you don't see any of these facts in this record unless we get discovery, which is when Rob Flaherty, who's deputy assistant to the president, sends an email to Facebook or to Twitter and complains that they're not doing enough to censor what they view as vaccine hesitancy speech. America never sees that. And the third party, people like Jill Hines and Jim Hoft, whose speech wishes to express the kinds of viewpoints that the White House is targeting, they never know that that's happening behind the scenes. And I think it makes a difference, Justice Kagan, that you have an intermediary here who really has no incentive to itself defend Jim Hoft's speech or to defend Jill Hines' speech. In the New York.
Now, at this point, the chief would chime in with a pretty, I think, amusing quip, followed by a fairly substantive point, that perhaps the Louisiana is looking at government speech too monolithically, and he goes on to make a statement that really leaves me worried that the chief is very much leaning towards siding with the government in the outcome of this case.
I was just going to say, first, I have no experience coercing anybody. But second, I mean, the government is not monolithic either. I suspect when there's pressure put on one of the platforms or certainly one of the other media outlets, they have people they go to, probably in the government, to say, hey, they're trying to get me to do this, and that person may disagree with what the government's trying to do this. It's not monolithic, and that has to dilute the concept of coercion significantly, doesn't it?
Your Honor, I'm not sure I agree with that, and I guess I'd get back to one of the earlier points I made, which is, whether you call this coercion, if that's the label you attach, you call it encouragement, you call it promotion, you call it inducement. Whatever it is, if the government is attempting to abridge the speech rights of a third party, that has to be unconstitutional because that falls within the plain text of the First Amendment. And so, this is Bantam Books of the 21st century. You haven't had a case with social media platforms like this where third-party speech is so at risk of being censored.
Well, but how do you analyze a situation where, maybe EPA is trying to coerce the platform about something and the Army Corps of Engineers is trying to coerce them the other way? I mean, you can't just sort of pick and choose which part of the government you're concerned about.
Your Honor,
obviously it's a different one. You're talking about what the president is saying in particular, but other than that, I think it's a very more a fluid situation than anything else.
It is fluid, Your Honor, but I would say that when you have, as we have plaintiffs in this case who wish to express certain viewpoints that have been specifically targeted by the government, it's not at least fluid in these facts. And this is not a case just about COVID. It's a case about election integrity. It's a case the district court has a finding about how the government
what
wishes
about
to.
that?
Now, next is another exchange between Justice Kagan and the Solicitor General, in which I think they both really just talk past each other and don't accomplish any greater understanding. Now, the reason I am including this portion is because I do think it is especially instructive about how Kagan looks at this case. And the reason that matters is mostly because I'm pretty sure the court will be coming down in the federal government's favor on this case. And if they do, I am almost positive that this majority opinion will be assigned to Justice Kagan to write. So, listening carefully to the following section, I believe, may be very instructive on what we can expect to hear when the majority opinion in this case comes out.
What I'm just trying to suggest is that there's all kinds of things that can appear on these platforms that do all kinds of different harms, and the inability of government that you're suggesting to reach out to these platforms and say, we want to give you information that you might not know about on this, and we want to give you our perspective on what harms that this is doing. And we want to be able to answer questions that you have, because we really do think that it would be a good thing if you, on your own, chose to take this speech down.
And, Your Honor, if those were the facts in this case, then I think it would be a much harder case for me. The government, this court has made clear for a while, since its plurality opinion in Alvarez, that if the government thinks there's false speech out there, the remedy for that is true speech. Nothing prohibits the government from going to that platform and saying, we've seen a lot of false information about election activity and COVID and vaccines and the like. Nothing prohibits the government from saying, here's a list of everything we say is true, that is true in our view, and you should amplify our speech. And anytime that false speech arises, you should put our post right there next to it saying, this is the government's view on this issue. The problem here, and this is, I think you see this in the summer of 2021, after the White House goes nuclear on the platforms, is that the platforms themselves reverse course on their own policies. In my view, one of the hottest docs in the JA, because you've got this email from Nick Clegg, who is, former Deputy Prime Minister of the UK, and after all of this pressure for months and months and months, he sends this email to Vivek Murthy, the Surgeon General, and he says, Dear Vivek, thanks for taking the time to meet. I wanted to make sure you saw the steps we took this past week to adjust policies on what we're removing, to take steps to further address the disinfo dozen. We've removed 39 profiles, pages, groups, Instagram accounts. We're continuing to make other accounts harder to find. This is an example of platforms moving beyond what their own policies require because they felt pressure to take more action and to censor more speech. And, Your Honor, if that's not the clearest example of the government
And next, we have two exchanges that I think highlight the problem that the Louisiana Solicitor General was having with conveying his ideas to the justices with any clarity. Here we have both Amy Coney Barrett and Justice Jackson struggling to understand his argument, which they say sounds inconsistent because, well, in all fairness at this point, it does sound inconsistent.
So can I ask you?
No, go ahead.
I want to go back to actually your interchange with Justice Kagan about the standards, because I have to confess it left me very confused. It sounded like you were articulating different standards depending on a different legal standard, depending on different factual circumstances. For example, so can you clarify? Did I misunderstand? Because it seems to me that as a matter of law, the same legal standard would have to apply across all of these areas.
I think that there's no emergency, nothing of the sort. They're just identifying
but
hundreds of
that's just kind of
accounts.
falling back on, well, this case is different, and so a different legal standard should apply. But, what we say in this case matters for other cases, too.
It does, Your Honor. But if what the FBI is doing is trying to persuade a speech intermediary to take down a private third-party speech, that is covered by the plain text of Norwood. And that's, an abridgment of speech. And
So I think that part of the reason why you might be running into all of these difficulties with respect to the different factual circumstances is because you're not focusing on the fact that there are times in which the government can, depending on the circumstances, encourage, perhaps even coerce, because they have a compelling interest in doing so. And so that's why I keep coming back to the actual underlying First Amendment issue, which we can isolate in this case and just talk about coercion. But I think that you have to admit that there are certain circumstances in which the government can provide information, encourage the platforms to take it down, tell them to take it down. Down?
No, Your Honor, because I think that would be a great example where strict scrutiny would cut in the government's favor.
All right. So what do we do? But you just seem to suggest that as a blanket matter, the government doesn't have the ability to, encourage or require this kind of censorship. And I don't know that that's the case.
So, Your Honor, I guess this goes to the bully pulpit as well. As I understand that the bully pulpit has never been used to target the object of suppressing a third-party speech. You can use it to coerce behavior. You can use it to coerce companies to take certain actions. But when the government is identifying a specific viewpoint and specific content that it wishes to wholly eliminate from public discourse, that's, I think, when the First Amendment problem arises. And so
Now, however, soon after this is when Justice Alito would step in, and I think he helps to point out to the Solicitor General that he is really sort of fucking up his side of the argument and gives him a very good chance to clarify and correct what were his previously confusing statements, which I do think he does a pretty good job of.
Thank you, counsel. Justice Thomas? Justice Alito?
Well, Mr. Aguinaga, I think some of your most recent colloquy with my colleagues have gotten off into questions that I didn't take it from your brief. You think we actually need to decide in this case. So I thought your principal argument was that whatever coercion means, what happened here is sufficient, and that coercion doesn't mean it doesn't apply only when the government says, do this, and if you don't do this, there are going to be legal consequences, when it says that in the same breath. But that it's a more flexible standard, and you have to take into account the whole course of the relationship regarding this matter. That's what I took to be your principal argument. Did I understand that correctly?
That's correct, Your Honor, and there's an entire volume. We've got 20,000 pages in this record of the government persistently going back to platforms again and again, pushing them to adjust their policies, change their policies, do more censoring. And I think that's what makes this case so unique, is that you not only have this vast repetition of communications, but it's all, again, the bulk of it is behind closed doors. And that's what's so pernicious about this, is that if we don't have a remedy in this case, then it's hard to see how there will ever be a remedy for a future plaintiff who turns out to be censored, but it's difficult for that person to even identify whether that censoring actually happened.
And you got all this information only through discovery, is that correct?
That's correct, Your Honor.
All right, thank you.
Now, at this point, Justice Barrett would pick up where Justice Kavanaugh left off earlier in the round of questions about what is it about a particular person that makes the speech they are engaging in inherently threatening. And I think the Louisiana Solicitor General here makes one of the very best points, because he goes back to a 2003 panel decision from the Second Circuit in a free speech case that Justice Sotomayor had sat on. Now, this was a case called Oquetti v. Molinari, and he points out that in that case, the panel decision, which Justice Sotomayor joined completely, actually completely backs up his argument. Now, he's right, and this is an entirely relevant free speech case, and I was not expecting this. Now, bear in mind, this is a circuit court case, which means it's not binding precedent on the Supreme Court, but it is relevant, and I think it really throws a wrench into the works of one of the two justices who have really been working him over and giving him an especially hard time. And for that reason, this was, I think, actually a fairly brilliant move, and I can't help but wonder whether he is just that good to think of this on the fly, or if perhaps he had this in his back pocket the whole time, waiting for the perfect moment to play it, because that's really what he did. he really played this card beautifully.
Justice Barrett?
Just picking up on Justice Kavanaugh's question about what makes something threatening, and is it just something inherent in the nature of a person, the person on the other end of the line being a government official. So Bantam Books points out that the speech, the threat, the encouragement, if that's, what we can posit for this purpose, comes from someone with the authority to impose a sanction. Is that important in your view?
Your Honor, it is and it isn't. We think it's a relevant fact that if somebody like an FBI agent that is meeting regularly with the platforms is making these kinds of requests, that's a fact that you have to take into consideration. Justice Sotomayor has a per curiam panel decision called Acquetti versus Molinari in the Second Circuit that addressed this issue about authority. And the issue in that case was that the borough president of Staten Island didn't have authority to take down a particular billboard, but the court still said that the fact that the recipient thought that the borough president might be able to use whatever authority he did have to cause trouble for the billboard owner, that was enough. So
now, the final moment that I want to touch on is a final exchange between the Louisiana Solicitor General and Justice Jackson. Now, this exchange includes the now infamous line by Justice Jackson about hamstringing the First Amendment. Now, I've already wrote an article and did a video on this because the people who have been attacking her are getting her all wrong here. So I will link to those on the show notes page. And since I've covered the controversy in great detail, I am going to skip that element of it here and just stick to the substantive argument. So essentially, this is actually the very last exchange of the whole proceeding, and I'm actually happy it ended here because this is the point where the Solicitor General finally understood what Justice Jackson meant about the importance of applying strict scrutiny in the First Amendment cases, and we finally, for the very first time, see him admit that he had misunderstood the point Justice Jackson had been trying to drive home. Now, this is very good because, despite the misrepresentation by many people of this exchange, Justice Jackson here is actually making one of the most important and correct criticisms of anyone during this whole session. And even, as you hear, the Solicitor General is smart enough to realize that by the end, where he concedes that he misunderstood her, and he finally finishes off the trial with a very good elaboration of the way his argument regarding government coercion is one that he was stressing because he sees that as a question on the front end of a First Amendment case. But he acknowledges that strict scrutiny is also an essential element, and he clarifies that that comes on the back end of a First Amendment case, that essentially you ask if there was coercion, and if there was, you then have to ask whether that coercion could survive the rigor of strict scrutiny. And he makes it clear here that these are both essential elements to any First Amendment case as part of a process of interpretation and construction. And he even clarifies that strict scrutiny plays an important function as a fail-safe mechanism, specifically related to many concerns that many people have had about the scope of the preliminary injunction, which people see as being exceptionally overbroad. Now, he doesn't agree it's overbroad, I wouldn't either, but essentially his point is that even if it were, for those who are concerned that this injunction stops the government from doing too many things that it should be doing, and he talked about such as protecting the vital national security interest, he points out that even under the broadest reading of the PI, the government always has the option on the back end to go to the courts and say, Your Honor, we see something that needs to be taken down for this or that reason. Here is the specific vital interest we have in upholding, say, national security, upon which this coercive measure is to be applied. And here is how we have tailored our request as narrowly as possible in the scope of executing that power. Now, there is one caveat that I would like to add to my general support of Justice Jackson's line of questioning along speech restrictions and strict scrutiny. Justice Jackson, it seems much like her predecessor, Justice Breyer, seems to be considering an approach that is more embracing of speech restrictions that she views as especially urgent. including perhaps ones that would depart from important precedents set in landmark cases such as the Pentagon Papers case. So, while I think that this goes too far, the discrepancy between her conception and my understanding of the relevant application of stare decisis is really just a difference of degrees. I do believe her underlying premise is sound, as both a factual and historical finding as well as a legal finding. Now, I want to again stress that I believe that this is one of the most important arguments coming from the bench during the entire session. That these contours of a judging coercion on the front end plus applying judicial scrutiny on the back end should have been at the center of this trial and not, as they unfortunately appear, a mere afterthought. Now, one final note here before I play this and we go. If you're not familiar with the basic concepts of judicial scrutiny, which I've been talking about a lot here, I have gotten into that subject a little bit in a recent video I made called First Amendment Fundamentals that I'll link to on the show notes page for this episode. But if people would be interested in a full video on the history and the legal theory behind the development of judicial scrutiny, let me know down in the comments section. Now, that's a very big, very complicated topic, and I probably wouldn't have time to get around to it until this Supreme Court term finishes in late June or early July, but that might make for a good episode during the lull from July to September between court sessions. So, that said, let's hear this final exchange between the Solicitor General and Justice Jackson.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. I mean, what would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And, Your Honor, I understand that instinct, and I guess what I tell you is our position is not that the government can't interact with the platforms there. They can and they should in certain circumstances like that present such dangerous issues for society and especially young people. But the way they do that has to be in compliance with the First Amendment. And I think that means they can give them all the true information that the platform needs and ask to amplify that.
Right, but you're just saying that. I guess I thought when you say the way they do that is consistent with the First Amendment is that they have to show that they have a compelling interest to do what they're doing. In other words, you want us to take the line to be between compulsion and encouragement. And what we're looking at is the government can't compel, maybe they can encourage. I'm wondering whether that's not really the line. The line is, does the government, pursuant to the First Amendment, have a compelling interest in doing things that result in restricting the speech in this way? That test, I think, takes into account all of these different circumstances, that we don't really care as much about how much the government is compelling, or maybe we do, but in the context of tailoring and not as sort of a freestanding inquiry that's overlaid on all of this. Does that make sense?
It does, Your Honor, and I apologize for missing your guidance earlier. So the way I think about that is I've been discussing the standard, and I thought we've all been discussing the standard on the front end of the analysis, which is there a First Amendment violation? Is there an abridgment of speech? I guess I would conceptually think of strict scrutiny, narrow tailing, compelling interest as coming in at the back end to say, yes, maybe in the ordinary case, the government shouldn't have been permitted to undertake the kind of suppression of free speech that it did, but in this unique circumstance, it actually had a compelling interest, and it used narrowly tailored means to accomplish that interest. I mean, I think that's the fail-safe. If you're concerned with the breadth of our arguments, that's one fail-safe, which is no matter how broad the standard the court adopts, there's always going to be strict scrutiny at the end of the line to save the government in times where it desperately needs to do the things that you're outlining.
Thank you.
All right. Well, that is going to do it for me here today. Thank you so much for tuning in to Legalese. Now, if you would please take a moment and do all of those things for me that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked this video, hit the like button. If you disliked it, the dislike button. I'd prefer if you hit the like button, but you have free will. You can do as you please. Subscribe to the channel so you always get notifications when I have new content coming out. Make sure to leave me a comment. Let me know what you thought about this video. Any questions you might have, any thoughts you might have, any suggestions for future videos that this might have inspired, or anything like that. And please be sure to share the show too. That's a huge way you can help us here. And it's totally free to do too. Just take a moment and post this to your social media, or think of a friend you know who would find this information useful or interesting, and send them the show real quick. And if you would do those things for me, I would be very grateful. And so until next time, this is Bob for Legalese, talking about Murthy v. Missouri, and, of course, as always, Carthago delenda est.